Right now in California, millions of gun owners are sitting on a legal time bomb. They own magazines that the state says are illegal. They own equipment that could land them in prison. And the courts have not finished fighting over whether that law is even constitutional. The case is called Duncan v. Bonta, and it just took the most serious turn, yet in its nearly decade-long journey toward the United States Supreme Court. If you live in California, if you own firearms, if you care about the Second Amendment, if you think the government should not be able to tell you what you can and cannot own, this is not a story you can afford to ignore. This is the story that could decide whether your rights still mean something. California has been fighting this battle for a long time. Since the year 2000, the state has prohibited the manufacture, import, sale and transfer of what it calls large-capacity magazines. The legal definition sounds simple on the surface. Any ammunition-feeding device with the capacity to accept more than 10 rounds. But that simple definition covers equipment that tens of millions of Americans own. Magazines that fit perfectly into the most common handguns in the country. Magazines that hunters, sport shooters, collectors and people who simply want to protect their families use every single day. California did not stop there. In 2016, the state went further. It banned the possession of those magazines. If you already owned one, you were required to surrender it, permanently alter it, or destroy it. That is when the lawsuit began. The case started before the possession ban even took effect. A group of California gun owners, backed by organizations like the National Rifle Association and the California Rifle and Pistol Association, filed suit arguing that the law violated the Second Amendment and also violated the Fifth Amendment by taking away property that people had lawfully acquired. That case eventually became known as Duncan v. Bonta, named after Virginia Duncan, one of the lead plaintiffs, and Rob Bonta, California's Attorney General. What happened next would surprise almost everyone who followed it. The case went to a federal district court first. Judge Roger Benitez, a federal judge in the Southern District of California, looked at the evidence, heard the arguments, and ruled in favor of the gun owners. He struck down the law as unconstitutional. He granted a preliminary injunction that blocked the state from enforcing the ban. That ruling was affirmed by a 3-judge panel of the Ninth Circuit Court of Appeals. For a moment, it looked like the ban might be finished. But the state appealed again, and the case eventually went before the full Ninth Circuit, what lawyers call an en banc hearing, meaning all the judges on the circuit would decide together. That first en banc decision came in 2021, and it was bad news for the gun owners. The Ninth Circuit reversed course and upheld California's ban. The majority opinion said that magazines were accessories, not arms, and therefore were not protected by the Second Amendment. The gun owners were stunned. But then the Supreme Court changed everything. In June 2022, the Supreme Court issued a landmark ruling in a case called New York State Rifle and Pistol Association v. Brune. That decision set a new standard for how courts should evaluate Second Amendment challenges. The court said that judges must look at the text of the Constitution and the historical traditions that surround it to decide whether a gun law is constitutional. It was a major shift in how these cases were decided. Based on that ruling, the Supreme Court took the Duncan case back, vacated the previous Ninth Circuit decision, and sent it back to be decided again under the new standard. When the case returned to the district court, Judge Benitez looked at it again with the Brune framework in mind. He ruled once more in favor of the gun owners. He granted summary judgment and a permanent injunction against the possession ban, but the state appealed again, and the Ninth Circuit took it en banc once more. This time, the hearing happened in March 2024. And the decision came roughly 1 year later, in March 2025. The result was the same as before, but with a different flavor. The en banc Ninth Circuit, this time by a vote of 7-4, upheld California's ban once again. The majority opinion, written by Judge Susan Graber, leaned heavily on the argument that magazines are accessories rather than arms. They said that the Second Amendment protects weapons that are part of the historical tradition of arms, and large-capacity magazines are more like equipment that enhances a weapon's capability, not the weapon itself. The judges who disagreed wrote powerful dissents, arguing that the majority was ignoring the plain text of the Constitution and the Supreme Court's Brune decision. But the majority view prevailed at the Ninth Circuit. Again. But here is where the story gets serious. The gun owners and their supporters did not give up. They did not accept defeat. On August 15, 2025, the plaintiffs filed a petition for a writ of certiorari with the United States Supreme Court. That is a formal request asking the highest court in the country to hear the case. This is not a small step. This is the biggest possible move in the American legal system, and it is exactly what many people have been waiting for. The petition is powerful. It argues that the Ninth Circuit got it completely wrong. It says that magazines are not accessories. Magazines are part of the firearm itself. They are what allows the firearm to function. Without a magazine, a semi-automatic pistol does not work. The petition points out that tens of millions of Americans lawfully own hundreds of millions of these magazines. They are among the most common firearm accessories in the entire country. If the government can ban something that common, the petition argues, then the Second Amendment means nothing. The petition also makes a Fifth Amendment argument. The government took property from people. People bought these magazines legally. They owned them legally. Then the government came along and said they had to give them up, alter them, or destroy them. That is a taking. The government took something that belonged to the people without paying them for it. That is exactly what the Fifth Amendment prohibits. But the petition does something else. It tells the Supreme Court that this case is the perfect opportunity to clarify the law. Lower courts are confused about how to apply the Second Amendment after Brune. Different circuits are reaching different conclusions. The law is inconsistent across the country. The Supreme Court needs to step in and give a clear answer. This case is ready. It has been litigated for almost 10 years. There have been 2 en banc decisions. The Supreme Court already remanded it once. It is time for the court to hear it and decide it once and for all. If you found that interesting, make sure you subscribe. This is exactly the kind of legal battle that shapes your rights for decades, and I will keep following it closely. The Supreme Court receives thousands of petitions every year and only accepts a small fraction of them. Most cases get denied without even being discussed, but this one has momentum. Less than 2 weeks after the petition was filed, a coalition of 27 state attorneys general filed an amicus brief in support of the petition. That is remarkable. 27 states from across the country signed onto a single document asking the Supreme Court to hear this case. The brief was led by Montana Attorney General Austin Knudsen, and it included states like Texas, Florida, Arizona, Alabama, and many others. This is not a partisan Republican versus Democrat thing. This is about constitutional rights. The brief makes the case that California's ban does not survive scrutiny under the Supreme Court's previous decisions. In the landmark case District of Columbia v. Heller, the Supreme Court said the Second Amendment protects weapons that are in common use for lawful purposes. The brief cites studies showing that over 500 million Americans own these magazines. They are unquestionably in common use. The ban fails the Heller test. It also fails the Brune test. The states argue that only the Supreme Court can correct this persistent misapplication of constitutional law. The other side is not silent either. Organizations like Everytown Law, which supports stricter gun laws, have already responded to the en banc ruling by calling it a life-saving decision. They point to research showing that shootings involving large-capacity magazines result in nearly 5 times as many people shot, more than twice as many people killed, and nearly 10 times as many people wounded per incident on average compared to other shootings. They say that 8 of the 10 deadliest mass shootings in recent American history involved large-capacity magazines. They believe the law saves lives. And there is another piece of this puzzle that matters. 14 states and Washington, D.C. have enacted similar bans on large-capacity magazines. Courts across the country have been asked to rule on these laws. Some courts have upheld them, some have struck them down. The law is a patchwork. In some places, owning a standard 15-round magazine for your handgun is perfectly legal. In others, it can send you to prison. That kind of inconsistency is exactly the kind of problem the Supreme Court exists to solve. The Supreme Court has also been active in the Second Amendment space recently. In 2024, the court decided United States v. Rahimi, another major gun rights case, and upheld certain restrictions on people under restraining orders. The court has shown that it is willing to engage with these issues directly. Gun rights advocates believe that if the court takes Duncan v. Bonta, it will rule in their favor. Gun control advocates believe the court will uphold the law. Nobody knows for sure. That is why this case matters so much. What happens if the Supreme Court takes the case? If the court agrees to hear it, the parties will submit written briefs, possibly including additional amicus briefs from other states and organizations, and then the court will hear oral arguments. After that, the justices will meet and vote on a decision. A decision in either direction would reshape the legal landscape for years to come. If the court strikes down California's ban, it would mean that large-capacity magazines cannot be banned. Every state with a similar law would have to repeal it. Millions of magazines currently illegal in places like California, New Jersey, New York, and Massachusetts would suddenly become legal again. People who surrendered their magazines under compulsion would have grounds to seek compensation. The entire debate over gun rights in America would shift dramatically. If the court upholds California's ban, it would mean that states have the authority to restrict these magazines. Gun owners in California and other states would face ongoing restrictions. Law enforcement would continue to enforce the law. The legal momentum that gun rights advocates have built over the past decade would suffer a serious blow. Some advocates would pivot to arguing for new legislation at the state and federal level. Others would focus on ballot initiatives and political campaigns. But there is also a middle ground. The court could take the case and issue a narrow ruling that clarifies how lower courts should apply the Second Amendment without definitively answering whether magazines can be banned. That would keep the case alive and send it back for more litigation, but it would provide guidance that courts currently lack. The truth is that nobody knows what the Supreme Court will do. The petition has been filed. The briefs are being submitted. The court will discuss the case in private conferences and eventually issue a decision about whether to hear it. That decision could come at any time, and it will matter enormously. For now, the law in California remains what it has been. The possession ban is technically in effect, though enforcement has been complicated by the ongoing litigation. People who own large-capacity magazines in California are technically required to get rid of them, but the legal landscape is shifting beneath their feet. The injunction that blocked enforcement came and went. Courts ruled and then unruled. The case went up and came back down. It has been a decade of uncertainty, and it shows no sign of ending soon. The people who are paying the closest attention are the gun owners who have followed this case from the beginning. They remember when Judge Benitez first struck down the ban in 2019 and called large-capacity magazines instruments of self-defense that are commonly used by citizens for protection. They remember the Ninth Circuit reversing that decision in 2021. They remember the Supreme Court sending the case back. They remember the second en banc decision in 2025. Through all of this, they have been waiting for a final answer. They are still waiting. The question you need to ask yourself is whether you are prepared for what comes next. If the Supreme Court takes the case, the decision will make headlines across the country. If it does not take the case, the Ninth Circuit ruling will stand, at least for now. Either way, the legal fight over gun rights in America is far from over. The Second Amendment is being tested in real time by real courts making real decisions that affect real people. The outcome of Duncan v. Bonta could determine what you are allowed to own, what you are allowed to carry, and how you are allowed to defend yourself and your family for the rest of your life. That is why I am asking you to share this video with anyone who cares about their rights. If you know someone in California who owns firearms, if you know someone who follows constitutional law, if you know someone who just wants to understand what is happening in the country they live in, send them this video. This story is not over. It is just getting more intense. The Supreme Court is watching. 27 states are watching. Millions of gun owners are watching. And now you know enough to watch too. The question is what you will do with that knowledge. If you want to see more content like this, hit the like button and let me know in the comments what you think should happen next. Should the Supreme Court take this case? Should states be allowed to ban these magazines? I read every comment and I want to hear your perspective. This is one of those stories where the ending is not written yet. The courts are still deciding. The justices are still deliberating. The future of the Second Amendment is still being shaped, and you are watching it happen in real time. Do not look away. This is exactly the kind of story that changes everything, and you are watching it unfold. Stay informed, stay engaged, and remember that your rights are worth fighting for, whether that fight happens in a courtroom or in the public square. The story of Duncan v. Bonta is the story of who gets to decide what freedom means in America, and the answer is still being written.